discussion on searches and seizures of Rule 126. What is a search warrant? Ano ang nature ng isang search warrant? A search warrant in your Rule 126 Section 1 of the Rules of Court. It defines a search warrant as an order in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. Always remember po that a search warrant is not a criminal action. Hindi rin siya, it does not also represent a commencement of criminal prosecution even if it is entitled like a criminal action. Ang isang search warrant, hindi rin siya isang proceeding against a person, but is solely for the discovery and to get possession of personal property. Ang isang search warrant is a special and peculiar remedy. It is drastic in nature and made necessary because of public necessity. Okay? A search warrant is also a legal process which has been likened to a writ of discovery employed by the state to procure relevant evidence of a crime. It is in the nature of a criminal process restricted to cases of public prosecution. A search warrant is a police weapon issued under police power, as cited in the case of United Laboratories versus ISIP. Okay? 461 SCRA 574. Lagi nyo pong tandaan na ang isang search warrant, wala yan relationship sa isang civil process. It is not a process for adjudicating civil rights or maintaining mere private rights. Ang concern ng isang search warrant is the public at large as distinguished from ordinary civil action. And of course, you should also know that the power to issue search warrants is exclusively vested with trial judges in the exercise of their judicial functions. Like an arrest, okay, the laws and rules governing a search warrant is based upon constitutional guarantees. Ano ang constitutional provision, okay, with regards to warrant, search warrant? We have your Article 3, Section 2 of the 1987 Constitution. Okay, anong laman ng Article 3, Section 2? Section 2 provides or states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. And no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and the particularly describing the place to be searched and the persons or things to be seized. Lagi nyo ring tandaan yung exclusionary rule. Okay? Ano yung exclusionary rule? Ang exclusionary rule is contained in your Section 3, Paragraph 2 of your Article 3 of the 1987 Constitution. Ang sabi doon, Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Ano ba ang pinagkaiba ng isang arrest at sa isang search and seizure? Ang pinagkaiba ng arrest sa search and seizure are the following. First, the rules on arrest are concerned with seizure of person. Ang inaaresto ay mga tao. Arrest involves taking of a person in custody. A search may follow an arrest, but the search must be incident to a lawful arrest. Ang searches and seizure naman po, it is of wider spectrum of matters on the search of both persons and places and the seizure of the things found therein. Ang probable cause sa arrest, okay? A probable cause to arrest does not necessarily involve a probable cause to search and vice versa. In order to determine probable cause to arrest, yung judge must have sufficient facts in his hands that would tend to show that a crime has been committed and that a particular person committed it. Ang probable cause sa search, it requires facts to show that particular things connected with a crime are found in a specific location. Lagi niyong tandaan na yung judge sa isang arrest, okay? The judge is not necessarily required to make personal examination before issuing a warrant of arrest. Okay? The judge naman, before issuing a search warrant, must personally examine the complainant and the witnesses he may produce, okay, in determining probable cause. Punta naman tayo sa time, okay? Ang pag-a-arrest po is made on any day, at any time, day or night. Pero sa search, a search warrant is generally served in the daytime, unless there be a direction in the warrant that it may be served at any time of the day or night. Okay? Punta tayo sa application for search warrant at kung saan magfa-file. As a rule, an application for a search warrant shall be filed before any court within whose territorial jurisdiction a crime was committed. Meron pong exceptions sa general na to. Okay? Sa general rule na ito, I should say. Okay? So, dapat lagi niyong tandaan nyo na mag-a-apply lang ng search warrant doon sa court that has jurisdiction over the crime. Okay? Kailan pwede hindi doon? Okay, number 1, the application may be made before any court within the judicial region where the crime was committed if the place of the commission of the crime is known. Number 2, the application may also be filed before any court within the judicial region where the warrant shall be enforced. Okay? Lagi niyong tandaan na it must be within the judicial region, okay? Kung saan na-commit yung crime or kung saan ma-enforce yung warrant. This is only for compelling reason. Okay? Kung hindi compelling, hindi yan applicable. Ano yung last? Okay? The last exception is the application shall be made only in the court where the criminal action is pending if the criminal action has already been filed. Sa pag-a-apply po ng search warrant, hindi kailangan ng hearing yan. Okay? It is ex parte. Ibig sabihin ex parte, hindi kailangan ng hearing ng court. So, an application for a search warrant is heard ex parte. It is neither a trial nor part of the trial. Kasi hindi po parte ng proceeding ang search warrant. Action on these applications must be expedited for time is of the essence. Okay? Ano yung mga property na subject sa search warrant? Okay? The following are the properties that are subject to search warrant. Number 1. The property subject of a search warrant is personal property. Pag sinabi nating personal property, hindi kasali ang lupa. Okay? Hindi kasali ang lupa. Because personal property is only those that are movable in nature. A search warrant may be issued not only for the search but also for the seizure of the following. Number 1, personal property subject to the offense, subject of the offense. Number 2, personal property stolen or embezzled and other proceeds or fruits of the offense. Number 3, personal property used or intended to be used as a means of committing an offense. Ang rule po natin dyan is only personal properties described in the search warrant may be seized by authorities. So, for example, in the case of People versus Nunez, GR number 177148, June 30, 2009. Search warrant number 42 specifically authorized the taking of shabu and paraphernalias only. By the principle of ejus dem generis, okay, the court explained, okay, where a statute describes things of a particular class or kind accompanied by words of generic character, the word generic will usually be limited to things of similar nature with those particularly enumerated, unless there be something in the context of the statement which would repel such inference. So, yung mga salitang ladies wallet, cash, grinder, camera, component, speakers, planer, jigsaw, electric tester, saw, hammer, drill, bolo. Yang mga salitang yan, those were not encompassed by the word paraphernalia. Okay? Because it has no relationship to the use of manufacture of drugs. So, if these items were seized during a search, the officers exercise their own discretion and determine for themselves which item were the proceeds of the crime or means of committing the offense. So these are the requisites for the issuance of a search warrant. Number 1, dapat meron pong probable cause in connection with one specific offense. Number 2, dapat the presence of probable cause is to be determined by the judge personally. Number 3, the determination by the judge must be made after an examination under oath or affirmation of the complainant and the witnesses he may produce. And number 4, the warrant must specifically describe the place to be searched and the things to be searched, which may be anywhere in the Philippines. Pag nagkulang or isa lang, may isang nawala doon sa 4 na requirements, it will cause its downright nullification. Okay? So what is probable cause again? A probable cause for search warrant means facts and circumstances which would lead reasonably discreet and prudent man to believe that an offense has been committed and the objects sought in connection with the offense are in the place to be searched. Yung sinasabing facts and circumstances referred thereto pertain. Facts and circumstances being referred thereto pertains to facts, data, or information personally known to the applicant and the witnesses he may present. Dapat yung applicant at saka yung witnesses, meron po silang personal knowledge doon sa circumstances na nagsusurround doon sa commission of the offense. Hindi po pwedeng reliable information lang. Reliable information is insufficient. Mere affidavit is also not enough, okay? Because, okay, personal knowledge of the commission of the offense is important. Probable cause does not mean actual and positive cause, nor does it import absolute certainty. Lagi nyo ring tandaan na under oath po dapat yung sa pagdetermine ng probable cause. Bakit kailangang naka-oath? Bakit kailangang oath or affirmation yung witnesses? Because the purpose is to convince yung judge, not the individual making the affidavit and seeking the issuance of the warrant of the existence of probable cause. We go to the particular description of place or person. It is settled by the court na yung description of the place to be searched is sufficient if yung officer with the warrant can, with reasonable effort, ascertain and identify the place intended and distinguish it from other places in the community. So any designation or description that points out the place to the exclusion of all others and on inquiry leads the officers unerringly to it satisfy the constitutional requirement. Paano naman po yung John Doe warrant? Okay? Yung John Doe warrant, which does not name the person subject of the warrant, is the exception rather than the rule. So sa John Doe warrant po, example in the case of Pangandaman versus Kasar. Okay? Dito meron pong 50 persons na John Does and none of which could be identified by the accused. Okay? We go to the particular description of the items to be seized. Okay? The provisions requiring a particular description of the items or things to be seized is designed to prevent general searches and avoid the seizure of a thing.